So thank you very much for inviting me, Hannah, and indeed, very nice to meet you all. It's a privilege to be here with you today to talk about a topic that has been at the center of my research and work for a number of years now. And in particular, what Hannah asked me to address and what I'm very happy to talk about is situations when the stars do not align, i.e. when human rights law and climate change law really don't walk hand in hand, but rather are at loggerheads with each other in the context of climate litigation. And in this connection, I have to make a few premises in order for us to understand what I mean by this assertion. So my plan today is really to talk a little bit about climate litigation and then to draw up some categories that I and others in the literature have identified to unpack this litigation, and in that connection really then zoom into the cases where we see this tension between human rights protection and climate change action. So first and foremost, a premise on climate litigation. Why are we at all having climate litigation? It's important that we remind ourselves where this all comes from. And this comes, of course, not only, but partially at least, from the Paris Agreement and the fact that it's a new treaty, of course. It has been adopted in 2015, but it has already engendered some discontent. Why is that? I'm sure I don't need to explain this to this audience, but the Paris Agreement has revolutionized climate governance in a way to be more comprehensive in the terms of parties' obligations, but it's also a very soft governance system. And this means in practice that it doesn't provide many means to hold states accountable for failing to meet the temperature goal that is enshrined in the treaty. So this prompted famous climate scientists to invoke the power of litigation in order to hold states and corporate actors to account for making sure that we get to the temperature goal envisioned in the Paris Agreement. And this is a quote from him from 2017 by James Hansen. And his call was promptly answered, I have to say, because if we look at the data concerning climate litigation, we notice that after the Paris Agreement was adopted, there has certainly been a spike in litigation. Climate litigation started to be accounted for and measured, if you like, in 2005, and the data we have is not complete. There is, however, two main centers that look at this litigation. One is the Grantham in London at the London School of Economics, and the other is, of course, the Columbia Law School Center. And these centers have for years been compiling data on climate litigation. And the data they collect clearly shows that litigation is healthy. It's largely taking place in the US, but it's increasing everywhere. And the data that you can see reported on this slide is pulled from the report Global Trends in Climate Litigation by Setzer and Hingham at the London School of Economics. So it's a must read for everybody interested in climate litigation, I have to say. So litigation is buzzing, but it's a very diverse set of practice. There is a lot in here that needs to be told and unpacked. And a number of scholars in recent years, I'm sure you know, has tried to look into the data and understand who is bringing this litigation and on what legal grounds. The main distinction that one has to draw is between what we call anti and pro litigation. What is anti-litigation? Anti-litigation is simply put litigation that is initiated to oppose climate laws or policies or projects. And it has a longer history than pro-climate litigation, to be honest. It has been around for a while. A lot of it took place in the United States, but it has happening everywhere. It's not only a US phenomenon. So it's really important that we appreciate that litigation is not only going one way in relation to climate change. Nevertheless, the literature and many scholars and commentators only focus on what we call pro-climate litigation, which is litigation that supports climate action. And this litigation typically asks states and more rarely corporate actors to take measures to either mitigate or adapt to climate change. And this can take very many different forms: the adoption of legislation, the adoption of policies, or the initiation of projects, and vice versa. The denial of authorizations to open, for example, new coal power plants, or logging of forests. This litigation is the litigation that, as I said, attracts a lot more attention in the scholarship. But I think that increasingly there is awareness that we need to understand both sides of the spectrum, because it's very important in the context of a transition away from fossil fuels to understand the motivations of anti-litigation. And this is what my presentation today will try and unpack by looking specifically at cases based on human rights law. So where is this litigation being brought? It's being brought a bit everywhere. And if you look at the data and the report by the Grantham that I just mentioned to you, you will see that there is the vast majority of litigations happening at the national level, so before national courts. There is, however, a fair bit of litigation happening at the regional and international level compared with the past. And here we have to be careful in the way with which we use the term litigation, because clearly, when we're talking about complaints before human rights bodies like the Committee on the Rights of the Child that delivered its decision on Monday, we're not talking about formal litigation here. We're talking about complaints before a UN body. Nevertheless, the litigation database bundle all this data together, and it's important that we appreciate that we're talking about rather different things from a legal perspective. What is interesting is that in recent years, we see more of these complaints before international and regional bodies. Nevertheless, we're talking about very small numbers still. So if you think about that, there is 2,000 cases logged into the Grantham database. International and regional complaints are very, very few. We're talking about 7 complaints at the international level, if I'm not mistaken, and a little few more at the regional level. So very, very small number of complaints happening beyond the national level. So let's zoom into pro-climate litigation, because I think it's interesting for us to consider a little bit what we know about this litigation and the way in which it's happening. With Joanna Setzer, we've done some work trying to unpack the role of human rights specifically in climate litigation. Why did we do that? Simple as that. We discovered that there was a spike in the use of human rights arguments in climate litigation. It started with Urgenda, but it was already present in the litigation before Urgenda. Nevertheless, it's fair to say that the first Urgenda decision was not particularly, if you like, strong on the human rights side of the case. I assume that most of you are familiar with that case by now, but I will tell you a little bit more about Urgenda later. The Urgenda case was, however, formulated largely on the basis of tort law. It's only at the level of appeal that the courts in the Netherlands decided to embrace vigorously the human rights arguments that had been put in the pleadings by the applicants. And this is where other applicants elsewhere really took heed from the Urgenda approach, if you like, and started to replicate that approach. So from there on, there has been a spike in the number of human rights cases, as you can see in this slide, in the diagram on the right. So people like Joanna and myself got curious and really wanted to know what was happening in these cases and what were people arguing. So we have written this paper together, and it's coming up soon in the Journal of Human Rights and Environment. And this is really what we did. We looked at the data collected by the Grantham and looked at all the cases based on human rights that were listed in the Grantham database and started categorizing them. The first thing we noted is that the vast majority of these human rights cases that are pro-climate are brought in Europe. This was not entirely a surprise, given the precedent of Urgenda that I've just mentioned, and the fact that in other countries, applications of similar kind started to be filed. At the same time, it's in contrast with the data we saw earlier that showed that the vast majority of climate litigation today is taking place in the United States. So here Europe is leading the pack, and after it, of course, there is Asia Pacific, where, as we, or you may know already, there is a lot of environmental rights case law at the domestic level, and then North and Latin America, and very few cases in Africa today. But we're talking in total about 112 human rights cases. The last time we counted that was in May 2021. So who is bringing these cases? These cases have been brought, or these cases could be brought in theory by different constellations of actors. The first and most common scenario talking about human rights is, of course, states being brought to court by non-state actors. And Urgenda is a very good example of that. In Urgenda, what happened is that a number of civil society organizations and applicants, individual applicants, got together in order to sue the Dutch government for not taking adequate climate action. As I said, they relied on tort law. But in Europe, we've had other cases that were brought by individuals, non-state actors against states. One of the most visible ones was the People's Climate case brought against the EU by a group of citizens, unsuccessfully, I have to say. And finally, of course, the third example I've got here is an example of an international complaint that is now before the Human Rights Committee and has been brought by some islanders in Australia against the Australian government. So this is states being brought to court by non-state actors, and this is the vast majority of cases. There is, however, a small but increasingly growing number of cases being brought by non-state actors against other non-state actors. And here we're talking about typically individuals and groups challenging corporate actors. The very famous case is that of Milieu Defensi, that have won this stunning victory against the Royal Dutch Shell in earlier this year. But before it, we had, for example, the carbon inquiry, the carbon mayors inquiry by the Philippines Human Rights Commission. Again, we're not talking about a formal judicial case here, but rather a complaint before a human rights body. So far, we've had no complaints at any level of states against states. There is a lot of talk today about an advisory opinion of the International Court of Justice on climate change, but it's fair to say that so far, at least, no case has been filed. So when they are bringing states to court or corporate actors to court, what are the applicants complaining about when they are relying on human rights? Two things. They may be complaining for lack of action, and therefore what I describe here as inaction, or for actions that the states have undertaken. So what do I mean by that? In the first scenario, we have applicants that complain that certain activities, like, for example, permits or licenses to extract fossil fuels, have led to human rights violations. You may have heard similar complaints being made, for example, in Norway, concerning the opening of new oil fields, but also in Latin America, where the logging of the Amazon was contested by some civil society organizations and groups. When we're talking about inaction, instead, it's a complaint about failure to act. And typically here we have failure to take adequate climate change mitigation measures, as in Urgenda, where the applicants were not complaining so much that the state had not passed any measures to address climate change, but that these were not good enough. And what these applicants argue, typically in these cases, is that this inadequate action is causing human rights violations. So let's look at now at how many cases complain about mitigation and or adaptation. And here you can see that in human rights-based litigation, the vast majority of cases are about mitigation. There's not many cases about adaptation, and a few about adaptation and mitigation together. Very few cases deal with the so-called matter of loss and damage. About 50% of the cases that have been decided so far were successful. But it's important that we know that not all wins were due to successful human rights arguments. Some of these wins were due to other legal arguments brought forward by the applicants. The other work that we did with Joanna was to look at which human rights were invoked in these different cases. And the thing that we did was to rely on the categorization of state obligations in relation to climate change and human rights operated by the UN Special Rapporteur on Human Rights and Environment in his reports on human rights and climate change. So the Special Rapporteur, if you're not familiar with his reports, have published 2 reports on this topic. And the first, published by John Knox in 2016, operated this distinction between substantive and procedural obligations of states. It's very much aligned with the practice. But it's also true that with the second report in 2019 by David Boyd, the Special Rapporteur was a bit more ambitious and kind of tried to articulate unwritten obligations, or rather responsibilities, of corporate actors in relation to climate change. And here, his approach was clearly normative. He, rather than trying to interpret existing practice, he was pushing the boundaries of the law in order to recommend an expansive interpretation of what we know as the business and human rights framework in relation to climate change. So here on this slide, you see the categories that we utilized on the basis of this report. On the one side, you have state obligations that are substantive in nature and divided in positive and negative. The obligation to adopt legislation, the obligation to enforce legislation on the one side, and the negative obligations of states to refrain from harmful activities, including authorizing them. It's fair to say that when we're talking about states, the vast majority of cases so far were concerning adoption of legislation. So in Urgenda, for example, the case was clearly about the quality of legislation, and the applicants were asking better legislation. It's notable, though, that more recently, what we are seeing is different kind of litigation that asks for the enforcement of existing legislation. So the applicants don't challenge so much the law anymore in its level of ambition. They simply ask that the law be enforced. And this is, I think, a very significant trend that can be justified by the fact that more and more states are adopting dedicated climate legislation that is more ambitious than in the past, but the problem is still that of enforcement. And we have that problem, for example, here in the UK, which is one of the countries with the oldest climate laws in the world, but still missing its targets, interim targets. So what these human rights complaints are really asking is for the state to comply with some laws. And if you're familiar with the European Court of Human Rights case law on environmental matters, this is a standard, if you like, approach to the implementation of environmental law in human rights case law. Finally, the negative cases are not as frequent and have not been as successful. What do we mean by negative obligations? They concern a request to refrain from harmful activities. I already mentioned the famous Norwegian case concerning oil and gas fields, the opening of new oil and gas fields. These are very difficult cases. There has been a lot of resistance by the judiciary to, as we will see later, invade what they consider as the sphere of the legislators and the executive in this connection. And the courts are very reluctant to move into that sphere. But there have been successful cases. The one in Ireland, for example, on the extension of a runway at an airport was exactly going in that direction, even though the victory was not obtained on the basis of human rights. Finally, the corporate side, the corporate actors. Here, as I said, the UN Special Rapporteur was being a little creative in the sense that he did interpret the obligations of states in light of the UN guiding principles on human rights, on business and human rights, but he did translate them into the climate context. And in this connection, he talked about the responsibility of business to reduce emissions and support climate policies on the positive side, and on the negative side, to refrain from harmful activities. And this is clearly, when you're thinking about corporations like Royal Dutch Shell, a very big ask, because being a fossil fuel corporation, you are engaged in harmful activities per definitions from a climate perspective. But what is really interesting in that these arguments that the Special Rapporteur made in his report in 2019 are being used in courts, and at least in the case of Milieu Defensi, they're being successful. We will talk a little bit more about Milieu Defensi later. Now, another thing that we discovered with Joanna when we looked at the data is that procedural obligations are not very commonly used in climate litigation. We were a bit surprised by this because, as you may know, in human rights and environmental litigation, procedural obligations are very commonly used, relying in Europe at least on the Aarhus Convention. So we were wondering why that may be the case. And we've hypothesized that the reason why procedural obligations are not very commonly used in litigation is because climate laws are relatively new. Not all countries have dedicated legislation on climate change, and they have really still a lot to do in terms of building the architecture to implement their NDCs. So this is one possible justification we gave ourselves. The other possible justification was that not necessarily activists in this area are as aware of the possibilities that are in this type of litigation, and they may be in the process still of finding their feet and understanding how measures that are being adopted to implement NDCs may be challenged. So these are the justifications we gave ourselves in as far as state actors are concerned. In as far as corporate actors are concerned, here we are talking about even more uncharted territory, if you like, in the sense that, as far as we know, there is no litigation really relying on this type of obligations for corporate actors, except for disclosure emissions. So this is a very underexplored area in terms of litigation presently. We don't have a lot of case law to work with right now when we're talking about corporate actors. But as you can see, the obligations that are on both sides of this slide are similar in nature, but clearly target different actors with different powers, and therefore what they're asked to do is different. And I'm really curious to see what's going to happen to this side of litigation in the years to come, because I would expect that as climate laws reach maturity, this kind of litigation will become more and more common. Also, as civil society kind of adjusts its strategies as the law matures and becomes more sophisticated. So, to summarize about Proclimate litigation, what I would say is that the vast majority of litigation based on human rights that is Proclimate today has three main, if you like, objectives. They want to raise awareness, of course, in the general populace and give visibility to the issues surrounding climate governance in the specific country. And many of these cases have succeeded. It's amazing how many people have heard of this litigation. It's not really something for lawyers alone. And people read about this litigation in the news and they pay attention. But eventually, the point is not for lawyers to become celebrities. The point is to change the practice of states and of corporate actors. And so this is the end game, and it's important to never lose that focus. In this connection, it's also very important not to underestimate the obstacles to this litigation, because we have clear limits to the powers of the judiciary and to what the judiciary can do. I already mentioned this in relation to the Norwegian case concerning oil concessions. Here, the judiciary really didn't feel it had the power to question the decisions made by the executive and the parliament. The other thing that may be an obstacle is the limits embedded in legislation itself. So when we're talking, for example, about the enforcement of climate laws, we can talk about the fact that there is often no specific consequences attached to the meeting of targets. And therefore, what can the judiciary do? If a government fails to meet its own targets, it's possible that moving forward, a rethinking of the way in which design climate laws is necessary if we want to put more pressure on states and corporate actors. Now, I will speak briefly about the two most famous cases that I have already mentioned to you. The first one is the Urgenda case. And here we're talking about a case that has been won at all levels by the Urgenda Foundation against the Dutch state. This is a very successful case for many reasons. The first one is that it has gone through the levels of appeal and successfully so. The second is that it's the first of its kind. It relied on tort law, but also corroborated by human rights arguments. In particular, what the applicants and the courts did was to interpret the duty of care of the state under Dutch tort law in light of human rights obligations of the said state under the European Convention of Human Rights, in particular Article 2, protection of the right to life, and Article 8, protection of family and private life. So this case really brought the established case law of the European Court of Human Rights into climate litigation. As somebody who has looked at this case law for a long time, I'm talking about the European Court, I thought it was a bit strange that nobody did that before. But as I explained, there are reasons why we are where we are with the litigation. And it was bound to happen. And it's good for these applicants that this happened in this case. And this is becoming mainstream. And I have recently edited a special issue of the Journal of Human Rights and Environment where the Urgenda folks have contributed a paper which will be released soon. And in this paper, they do look at the cases that have relied on the same arguments elsewhere. Cases in Italy, cases in many other countries. And it's really interesting how this has become a template for litigation all over Europe and beyond. The most adventurous, however, case to build on Urgenda is not a case against states, but is a case against a corporation, Royal Dutch Shell. And again, I don't have a long time to talk about this case, but this is potentially even more revolutionary than Urgenda. Why? Because, as I said, with Urgenda, it was easy to identify an established body of case law under the European Court of Human Rights concerning Article 2 and Article 8 and say, okay, the state is not doing what it should be doing in order to protect the rights of the citizens. But here we are talking about a corporate actor that, strictly speaking, formally speaking, doesn't have obligations under human rights law. Nevertheless, the applicants ran the same line of argumentation against Royal Dutch Shell and won. How is this possible? The court that decided the case in the first instance only, this is a case that is under appeal presently by Royal Dutch Shell. The court considered that the various soft law instruments that exist in relation to corporate responsibilities in Europe configure specific obligations for corporations like the Royal Dutch Shell, and that these obligations have been breached. Again, the same line has been operated, and therefore we're talking about tort law and duty of care, and the duty of care interpreted in light of human rights obligations. It's a very ambitious and generous interpretation of the law. And, you know, it's really going to be interesting if it stands the scrutiny at the appeals level, because if it does, and a lot of people didn't think that Urgenda would survive at the appeals level, then the domino effect could be comparable to that of Urgenda. But we will have to wait and see for that. There is more cases that are path-breaking in different ways. The first one that you have on the top is, of course, the first case before the European Court of Human Rights, filed by a group of Portuguese children against 33 member states of the Council of Europe. This is a pending case, and there is another 2 now before the European Court of Human Rights. The first 2 cases have been fast-tracked, but even so, we're not expecting a decision anytime immediately. I can't wait to see what the court is going to do, because these are cases that are very interesting for a number of reasons, and not only because they are before the European Court of Human Rights. The second case you have on this slide is actually a complaint before the Committee of the Rights of the Child that was decided very recently and controversially. Very happy to have a chat about this in the discussion. I don't want to take a lot of time here, but clearly we are seeing a complaint before an international human rights body by a group of children from various countries against various states. And there was much anticipation of the outcome of this complaint. And I think a lot of people were disappointed by the findings of the committee here on Monday. The committee basically on the substance agreed with the applicants, saying that climate change violates a number of children's rights. Nevertheless, the applicants really have to exhaust domestic remedies before they go before the committee. And this is interesting because the first case in the slide, Duarte Agostino, made similar argument about the exhaustion of domestic remedies. So it's going to be interesting to see what the European Court thinks about that. And the last case on the slide is the Torres Islanders case that I've already mentioned. And that is important and interesting because it deals with, if you like, the issue of loss and damage. So I said not many cases deal with adaptation and loss and damage, but this actually does, because these islanders will lose their homes and really the place where they've always lived as a result of rising sea levels, and they accuse Australia of not doing enough to put a remedy to this situation. So again, a very important complaint before an international human rights body that could be a path breaker. Now, we have talked a lot about Proclimate cases, and now would really like to do what the title of my presentation today says, and it's looking at anti-climate litigation that is based on human rights. This is what we described with Joanna as the far side of the moon. It's the side of the moon we know less about. It's, however, a very important part of the picture. Why? Because, as I said, we are seeing an increasing number of cases against climate action that are based on human rights. And with Joanna, we tentatively call these cases just transition litigation. Why? Because basically what these applicants are arguing, as you will see, is that the measures adopted to address climate change violate human rights. And this is unfortunate. It shouldn't really happen. And we are really curious to find out why this is happening. So a long time ago by now, I wrote this paper in a very good volume edited by a group of esteemed colleagues. In this volume, I basically noted something that we by now know quite well. And that is that while in principle there's no incompatibility between climate action and human rights protection, in practice, conflicts between the two may and do emerge and have emerged in practice. I wrote about this already in the context of my PhD dissertation quite a long time ago. So the very complicated operation the states have to undertake as they adopt measures to implement their NDCs is really to make sure that they do what the Paris Agreement preamble asks them to do and take into account their human rights obligations as they do undertake climate action. So with Joanna, we started to look at the case law and see what we could say. And immediately we realized that we don't have a lot of data. There is some anti-climate cases collected in databases, but we realized that the most cases we knew were actually not in the databases. Why is that? The reason why the climate databases don't pick up these cases is because these cases are not about climate change, first and foremost. These cases are instead about other issues like planning law or about civil rights, but they don't necessarily get formulated in terms of climate law. And this is important because it means that there is a gap in our knowledge and also in the way we collect knowledge about climate litigation. So the vast majority of rights-based complaints that Joanna and I could identify on the basis of the literature and anecdotal evidence that's thrown up by our research is that in the vast majority of these rights-based complaints, climate change is an incidental or peripheral consideration. The applicants don't really mind climate action. They are not against climate legislation. They're not against the government taking action on climate change. What they mind is that their human rights are being violated. So many of these cases concern power plants based on biomass, wind farms, a lot of cases about wind farms, and similar projects. So rather than a policy or a legal instrument, what these cases typically do is to challenge one specific activity, one specific project. And many of these cases are brought on the basis of procedural obligations. So what these applicants typically complain about is the fact that they were not consulted, that they were not informed, or that they didn't get access to remedies. So if you like, it's almost the opposite picture that we see in relation to pro-climate cases. So this is just a couple of examples of cases we know of. One of them is REDD+, and I assume you have heard of REDD+ before, but this is really measures that were adopted under the climate treaties in order to incentivize forest carbon sequestration in the tropics, in developing countries. What happened with these measures was that they ended up causing human rights violations of an egregious nature. Dispossessed communities that were prevented from exercising their cultural rights, their traditional rights over areas of forest because of REDD. And while REDD was clearly aimed to tackle the climate crisis, it was also affecting negatively small and marginalized communities that depended on forests. So there have been complaints about REDD+, and this is just one of a few that I have picked up in my work a long time ago in my PhD on a piece of legislation that was adopted in Indonesia. And basically the Committee for the Elimination of Racial Discrimination told off Indonesia for the way in which it was adopting red legislation, and told it to change its course, which I'm happy to say Indonesia did. But to begin with, the approach that had been suggested and taken by the government was really that of encroaching upon the rights of indigenous peoples and tribal communities. The second example that I want to give you is that of wind farms. I don't know if you heard, but there has been quite a lot in the press about the violation of indigenous peoples' rights in Mexico because of the establishment of large-scale wind farms on indigenous peoples' lands. And again, here we're talking about communities that are already marginalized and vulnerable, and the adoption of measures to deal with climate change has affected them particularly disproportionately in a negative way. And this is a paper that I wrote with a colleague. There is a paper that I wrote with a colleague on this topic if you're interested. You find all my papers on SSRN. Very recently this week, there was an important decision by the Norwegian Supreme Court on a similar issue, but this time we're talking about the Sami. And what the Supreme Court of Norway did was exactly to highlight the human rights violations that were carried out through the authorization of wind farms on lands used by the Sami for their traditional herding practices. So we're seeing cases of this kind happening everywhere. So how do we deal with this predicament? We need to transition away from fossil fuels. We need wind farms, we need REDD+, but we also need to protect, respect, and fulfill human rights. And this is, I think, where the resolution that was adopted by the Human Rights Council last week marks an important moment. Why? Because I don't know if you had the chance to read the resolution, but one of the things it did was, of course, to appoint a special rapporteur on human rights and climate change. And one of the things that the rapporteur is asked to do is to promote a rights-based approach to climate action. What does that even mean? Well, it's a job of the rapporteur to tell us, but if you ask me, it's exactly to deal with tensions like the ones that I just highlighted for you. So I believe that we really need to look with a magnifying lens now, not so much to the pro-climate case, but to the anti-climate cases, to understand where the human rights violations are occurring in the implementation of climate change response measures, and to do better. Learn from our own mistakes, if you like, and really address the root causes of those human rights violations so that we have a just transition away from fossil fuels. In this connection, I recently wrote a paper with my colleagues, Sébastien Jourdain and Margareta Wewerinke, where we do talk about the way in which, human rights can be used and should be used. So in this regard, there is a need to ensure policy coherence, and some of this work has already been attempted, for example, in relation to REDD+. I'm not gonna argue that REDD+ has been an unmitigated success, quite the opposite. What I'm saying that the problems that have been experienced with REDD+, because it's been around for quite some time now, are being experienced across the board, and there are lessons to be learned from what institutional actors have done in order to mitigate the tensions with human rights protection in the implementation of REDD+ measures. Of course, the ILO has adopted some guidelines for a just transition, which are a starting point as well, more generally when we're talking about workers' rights. But in general, what the special rapporteurs have said in this regard is already important and a good point of departure. States really must not cause harm when they adopt climate change response measures. So they have to strike a balance, John Knox wrote famously, but this balance cannot be unreasonable and result in unjustified foreseeable infringement of human rights. So probably the wind farms in Norway could have been built somewhere else and not on Sami land. Or if they were going to be built on Sami land, maybe they had to be better engaged with the local communities. The communities had to be heard, consulted. Yet clearly this has not happened in the way it should have happened. Non-discrimination is fundamental here. Of course, we always have to be mindful of the rights of especially vulnerable groups, minorities, and of course, women, children, and indigenous peoples. Procedural rights, as I said, I think have a bright future, simply because, again, here we are building a rich body of case law, especially in Europe with the Aarhus Convention, but also in Latin America with the Escazú Agreement. And now it is entered into force. So what we really have to do is to mainstream that and make sure that, for example, the grievance mechanisms that have been established already to protect the rights enshrined in the Aarhus Convention are systematically used also in relation to climate change response measures. And this is, of course, the job of civil society organizations, but also our job, if you like, as academics, to inform and really make this point when we are talking to policymakers and lawmakers and also to our students. In this regard, the state obligations are the ones that we know very well. It's very important, though, that there is this understanding that opposition to, for example, wind farms and similar projects needs to be understood. Lessons really have to be learned from opposition. It's not good enough to say, this has to happen because we have to transition. We have to move to net zero emissions. Too bad for you if this happens at your expense. There has been a little bit of this mentality, and I do understand why, but this mentality is misplaced because the truth, and I've seen that firsthand here in Scotland, the truth is that when you don't have the local communities with you, there is going to be a lot of trouble, protests, litigation that will eventually slow down the process of establishment of wind farms and so on. So it's much better, much better to do things properly from day one and to actually make sure that rights are respected. So you have your community on board when implementing projects like wind farms. And again, the guidance from the UN Special Rapporteurs on Human Rights and Environment is useful, but I'm looking forward to see more from the Human Rights and Climate Change Special Rapporteur in future. So as I said, there are a number of things that can be done and should be done. And I think that the mainstreaming of climate change in human rights parlance is happening at speed now with these two human rights resolutions last week. Human rights mechanisms will be used more and more as we proceed in the process of mainstreaming climate action and implementation of NDCs. So we should all be prepared for that. I have to say some of the early conversations I had with climate litigants about human rights law were almost mini lectures about what they could get from human rights law. But I think that there is a snowballing effect now, and people are really appreciating the potential of using human rights law in this area more and more, both for pro and anti-climate cases. In this connection, capacity building is fundamental. I'm personally engaged in this exercise with national human rights institutions that are an important first port of call for a lot of these complaints like the ones that I've just described. I hosted a session earlier this year where we had guests from national human rights institutions, and I was explaining to what I'm explaining to you because they wanted to know about climate litigation. And when I was talking about the wind farms cases, I said, oh yes, we see lots of those. I said, yes. So connect the dots and think carefully about what can you tell about these cases or these complaints? What are the best practices? We need to see, if you like, a joint picture, because we all need to learn from one another how to resolve tensions of this kind, what best practices governments should follow in order to make sure that they achieve their climate goals, but also protect human rights. And this is really what I want to leave you with, the conclusions that Joanna and I draw in our paper. That human rights is a very important tool to address the accountability gap left by climate law at the international and the national level. Human rights are especially important when there is nothing else that the applicants can actually use. The Filipino complainants against the carbon mayors, the Torres Islanders losing their land, the children against the states that I mentioned earlier. All these applicants could potentially go before one domestic court, but it's very many times much easier for them to formulate their complaints in terms of human rights. Access to justice is more prompt and more forthcoming, even though their complaints are not necessarily successful. What these cases do, whether successful or unsuccessful, is to throw up and give a visibility to the many justice questions that are associated with the transition away from fossil fuels and the race to net zero. Especially here in Europe, we are about to see a transformation of our societies, with a move away from coal, with the moving away from practice in agriculture that have become mainstream but need to change in order to accommodate the transition away to net zero. So it's going to be painful. It's going to be hard. And I think that it's important to remember that human rights must be a part of this conversation if we want to get this right and bring everybody in society with us. Otherwise, it's going to be even harder, and it's already hard. Thank you very much for listening, and I very much look forward to discussing the ideas I shared with you. Thank you.